in Kansas. Okay, welcome everybody to this morning's session of the Kansas Court of Appeals. I'm Chief Judge Karen Arnoldberger and the presiding judge of this panel today. Joining me are Judge Tony Powell from Wichita, and we are really pleased today to have Judge Amy Fellows Klein on her very first docket sitting with us as our newest judge on the Kansas Court of Appeals. I'm going to ask the parties to enter your appearance, if you would, please.
Tucker Poling on behalf of the Kansas State Board of Healing Arts.
Okay.
Appellee Kezia, appearing by attorney Ryan Cox.
Okay, thank you very much. As you both have argued before us before, I believe, but just keep in mind that we've read the briefs. In some cases, we've read the entire record of your case. So we're very familiar with the facts. You only have 15 minutes to argue, so or to present your argument. So you don't need to spend a whole lot of time with the facts. And in fact, in this case, the facts aren't really in much dispute at this point. So with that, Mr. Poling, did you wish to have any rebuttal time?
Yes, I would like 5 minutes for rebuttal.
Okay, you've got it. And you may begin as soon as you're ready.
May it please the court.
Go ahead.
We're here because the May 2018 final order issued by the board in this case was lawful and the district court had no lawful grounds to disturb it. This is a case in which an appellee engaged in repeated instances of professional incompetence and misconduct in the form of gross negligence and improper record keeping in the treatment of 3 pregnant patients. As the district court admitted, quote, "There is a myriad of evidence to support the conclusion of misconduct, professional incompetency, and gross negligence," end quote, relating to each of the 3 counts of professional misconduct that were alleged in the administrative petition for discipline in this case. And given the very serious and dangerous nature of the professional misconduct found in this case, the board's exercise of its discretion to revoke Appellee's license was not arbitrary, capricious, or outside the bounds of reason. We're asking this court to affirm the board's final order and vacate the district court's order. The board's order is entitled to deference from this court, and the district court decision is entitled to no deference by this court. This statutorily defined standard of deference to the agency order throughout the life of a KJRA appeal process is defined at KSA 77-621A1 and A2, and was clarified by this court in the 2018 case of Carlson Auction Services, Inc. versus Kansas Corporation Commission, 55 CANAP 2D 345. The district court erroneously vacated the board's order based on 2 statutory grounds that were errantly applied by the district court. Those 2 statutory grounds were KSA 77-621A7 and A8. The first statutory ground, KSA 77-621A7, requires that the agency order must be based on determinations of fact that are supported by substantial evidence in the agency record. And in this case, as I've already referenced, the district court agreed, quote, "There is a myriad of evidence to support the conclusion of misconduct, professional incompetency, and gross negligence," end quote, as to each count of professional misconduct that was alleged in the administrative petition. So there's really no issue in this case relating to the substantial evidence requirement. Under the plain language of KSA 77-621A7, the substantial evidence standard applies to findings of fact, not the exercise of discretion in determining an appropriate sanction. The second statutory ground on which the district court relied, KSA 77-621A8, requires that orders of the board not be arbitrary, capricious, or outside the bounds of reason. But instead of applying that standard appropriately, the district court simply substituted its judgment for the board's on the issue of the appropriate sanction in this case. What happened in this case is that the district court vacated the board's chosen sanction and replaced it with a sanction that had been proposed in an initial order issued by the administrative law judge that had conducted the administrative hearing in this case. And the district court's approach to this case is encapsulated in what I'll call Goldilocks quote, which is on page 94 of volume 3 of the Record on Appeal. The district court wrote, quote, "The ALJ sanction was proper. It was neither too lenient nor too punitive. It was a sanction commensurate to the petitioner's violations," end quote. But the problem with the district court's approach is that the district court was not tasked with deciding one proposed sanction was too hot, one was too cold, and this other one was just right. This was a KJRA appeal in which the board's final order sanction was presumed valid and should have been reviewed independently with deference and without regard to the sanctions suggested by the ALJ in the initial order. And on this point, it's important to realize that under the Kansas Administrative Procedure Act, as applied to healing arts cases, the board's review of an initial order from the ALJ is completely de novo. There is zero deference given to an initial order. The second underlying error in the district court's analysis is actually more glaring in our view, in that the district court's reliance on the fact that the board did not seek an emergency suspension in this case as grounds to support the district court's conclusion that revocation must not be appropriate to protect the public in this case. The district court's reasoning on that point flies in the face of the clear intent of the legislature in the statutes that control emergency proceedings, KSA 652838 and KSA 77536, which make very clear that those are extraordinary ex parte proceedings in which the board must meet a heightened standard of imminency to show imminent danger to the public that would require an ex parte emergency suspension proceeding.
If you don't mind, I have a couple of questions that I want to be sure and ask. The first is the procedure that happens here, the way I understand it, is a complaint is filed. There's a board, a peer review board that reviews the results of the investigation and makes recommendations as to whether to go forward with a formal action or not. And then that formal action then goes before the ALJ, and the ALJ makes a determination. And then can both parties accept the ALJ determination? And then does it end there? Or does it always go to the board?
Your Honor, it does not necessarily always go to the board. The Administrative Procedure Act provisions that deal with this are KSA 77526 and KSA 77.
Right. I'm just asking, yeah. Are there situations in which it ends there?
It could be, and those situations, as defined by KSA 77, 526 and 527, are if neither party requests a review of the initial order, right, then the initial order by default will become a final order after 15 days with neither party requesting a review.
Okay, all right. Go ahead.
Importantly, if in the more usual occurrence where one or both parties request a review by the board, the Administrative Procedure Act essentially makes that initial order effectively a nullity. It never becomes an effective order. Right. And the board's review is completely de novo. And the case law has emphasized, especially in regard to Board of Healing Arts cases, that there is an expectation of deference to the board and their expertise on these matters.
Okay. And in this case, and I know I'm skipping ahead to the costs issue, but in this case, the ALJ at the conclusion of the matter assessed costs against Ms. Shine. But it doesn't, there was no discussion of an amount, and I don't know that, were costs ever submitted to the ALJ as far as an amount of costs, or did that not come up until they were presented to the board?
Your Honor, that doesn't happen until after the ALJ proceeding is completed, because the statute on costs includes costs of the ALJ's proceeding itself. So what happens is the ALJ proceeding occurs, the initial order says whatever it says. In this case, it said costs were to be paid by Dr. Shine. And then a statement of cost is filed by the disciplinary panel. So 30 days before the hearing on review of initial order before the board in this case, the disciplinary filed their statement of costs because costs had been suggested awarded by the initial order that was filed with the board. In this case, there was no response to that. And so really no one ever contested that these were reasonable and appropriate costs for the investigation and prosecution of this case.
Because nobody would have had them at that point, wouldn't have known what they were.
Well,
You got to,
Your Honor, they wouldn't have known what they were until the statement of costs was filed. And the statement of costs was filed a good 30 days before the hearing, the review of initial order hearing before the board.
Okay.
May I interrupt for a moment, Chief?
Yes.
On that, just that one point about the statement of costs. Is that in the record? I looked for that, and the record's fairly voluminous, and I couldn't find it specifically. But is that in the record, and does it itemize what the costs were?
It does. Yes, Your Honor. It's in the record, volume 7, page 725 is where it starts.
Volume 7, 725.
Correct.
Excellent. Thank you very much.
And it does.
One other question, Mr. Poling. In a case, and I'm assuming you don't have a lot of cases where revocation of a license is at stake, but how long do those cases normally take? There's a lot of talk in this case about, 3 years, 5 years. Is this typical, not typical?
Well, I'd say that the administrative litigation in this case, was a lengthy one. I wouldn't say it was, truly extraordinary, but just like civil cases, sometimes the administrative litigation goes on for quite some time. It's very, when you get to a serious case like this, where there are very serious allegations, it is litigated, in terms of the discovery, depositions, that kind of thing, expert reports, people depose each other's experts. You go to a pre-hearing conference, all that kind of stuff. That is similar to a civil case. And in this case, this was a quite involved case and a very serious case. So it did extend for a few years.
Okay. Judge Klein, did you have any questions you wanted to ask? You're about at the end of your time, Mr. Poling.
I don't. Thank you, Your Honor.
Okay. So I've taken up a lot of your time by asking questions. So I'll give you a minute or so just to sum up, and you'll still have your 5 minutes of rebuttal.
Chief, may I ask a couple questions?
Oh, I'm sorry. Go ahead. Yes.
I wanted to ask Mr. Poling about the standard that we're to look at for arbitrary and capricious action with regard to the sanctions here. Is your position that the board's time that it took, or its lack of action with regard to an emergency, suspension of the respondent's license here, that we're not to consider that? I guess I'm looking at a difference between the authority to discipline and revoke a license versus the discretionary act, and whether that we consider those facts in terms of the reasonableness of the board's action here. Do you agree with that that's something we can look at in determining the reasonableness of the board's action here, or not?
I do not, Your Honor. I do not agree with that. To hold that against the board in the context of the final resolution of an administrative petition, we believe is improper, because the law clearly directs us that the default procedure, even when the disciplinary panel of the board believes revocation is ultimately the appropriate sanction in the case, the usual administrative litigation and hearing process authorized in KSA 652836 and the Administrative Procedure Act should be the default procedure. And the statutes that control the ex parte emergency suspension proceedings, KSA 652838 and 77-536 make it clear that those are extraordinary proceedings and should not be the normal course of action when the board feels, every time the board feels a revocation is appropriate, you go for an emergency suspension. We think it's clear from the context of the statutes that that is not what was contemplated. There's a lot of things that go into that. It's just like, it's similar to, maybe an emergency preliminary injunction in a civil case, and then holding that against the party later on the merits, at trial. We think that would be similarly inappropriate.
What about the time? What about the fact that the board took several years to implement this discipline here? Can we look at that? Is that fair game to look at?
Well, it depends on how what you're looking at it for. I don't think it's fair game to look to say, because the litigation extended, for an extended period of time over years, that should be held against the board. Frankly, it takes two to tango in that regard, and there was a lot of administrative discovery and pre-hearing litigation that occurred by both sides on this case. So I don't think it's appropriate to hold it against either side, frankly, that kind of, really robust, due process was engaged in. I think that where you get it, where it becomes problematic, the timing becomes problematic, is where the appellee and frankly the district court is trying to confuse the absence of evidence with the evidence of absence. So appellee wants to argue, well, because there's been no other disciplinary actions, since this action occurred, that means my practice has been perfect since then. And we know that that's just not the case, that's fallacious. There's a lot of examples in that regard. There's, a case that has become part of the public consciousness is the Dr. Larry Nassar case from Michigan. Now that was a case involving much more, the most severe conduct that you can really think about. It was criminal assault, essentially, by a doctor. And even in that case, where this physician is abusing these USA gymnastics athletes, 10 years passed before even a single complaint was filed. And so, the Dr. Nassar's lawyer could have said before the first complaint was filed, hey, look, I've had no board disciplinary complaints filed. That means my practice has been perfect. And that just shows the fallacy of that.
Thank you, counsel.
Okay, just take about 30 seconds if you need, Mr. Poling, and then we'll move on to Mr. Cox.
I just wanted to point out that a third error in the district court's analysis very quickly is in failing to account for the fact that after the ALJ issued her order, in which the ALJ found that it was likely the appellee had changed her ways and stopped doing these things to pregnant patients, appellee testified at the hearing in front of the board on the review of the ALJ's initial order that she has not changed her practice in any way other than record keeping. So that fact contradicts the district court's conclusion that there was no rational basis for the board to determine the lack of potential for rehabilitation was an aggravating factor in this case. And I'll defer the rest of my argument to rebuttal.
Okay, thank you very much. Mr. Cox?
May it please the court. What Mr. Poling neglects to bring up is the fact that no patient has ever complained about Dr. Shine's treatment or been harmed or injured in any way, shape, or form. This entire deal was orchestrated by a business competitor who lodged 18 complaints, only 3 of which stuck. So,
do we even get to that, Mr. Cox? I mean, there's a pretty much an agreement. I don't know how we get past the fact that the ALJ, the board, and the district court all found that this was grossly negligent or incompetent or whatever that standard was that they use in assessing doctors. So, is that really up for us to consider at this point? Aren't we here arguing the costs and the penalty?
We are, but I think it falls into the, 77-621 was revamped in 2009 to lessen the burden to disqualify an agency action. And obviously, agencies have the potential to abuse their power, and that's what happened here. When you look at the changes, the 2009 changes, And Mr. Poling inadvertently referenced A7 and 8. It's actually C7 and 8 with respect to substantial evidence and arbitrary and capriciousness. So what the legislature did is in subpart C7, they added a phrase about evidence being supported to the appropriate standard of proof by evidence that is substantial and viewed in light of the record as a whole. And then they actually added a whole new subsection D defining in light of the record of a whole, referencing the need to consider relevant evidence that detracts from the agency's finding of fact. So in this situation, all Judge Mason did was looked at the evidence that existed, analyzed it, and came to the ultimate conclusion that the record as a whole does not support the sanction of revocation. And case law subsequent to 2009 explained that basically there's three things that help a reviewing body analyze or disqualify agency actions, which includes looking at the evidence that detracts or diminishes from the agency action, deference to the presiding officer who had an opportunity to observe the demeanor of the witnesses, and analysis of the agency's explanation as to why the relevant evidence supports its findings.
Well, it's clear that the ALJ and the district court put a lot of emphasis on the fact that there have been 3 years or 5 years or whatever without any other complaints. Correct? Would you agree that, plus the fact that she had not had any complaints before then?
Yes.
Those were basically the two mitigating factors as opposed to the aggravating factors of the gross incompetence, correct?
Yes.
Okay. So,
and also undergone probation, has had a chaperone. I mean, the board acts like it's trying to protect Kansas citizens, but no one's actually been injured.
And you believe that they need to wait for someone to be, that no one can have their license suspended unless they've injured someone, in fact?
No, I don't necessarily believe that, but the Pfizer case that stands for that proposition, even in that case, there was an actual injury. I mean, I think just preparing for this, diving into what ALJ Sharon and Judge Mason said, they went through all the factors in great detail, and the 89-day sanction and did its job to the extent it was necessary. I mean, there haven't been any complaints, and I think to try to compare it to the Nassar situation is apples and oranges, quite frankly.
Okay, I have another question for you here. You say on page 10 of your brief, the board has been on an apparent quest to revoke Dr. Shine's license for over 5 years. Can you explain that comment to me? I mean, how did the board embark on a quest to revoke her license when they were simply investigating allegations that were brought against her? How do you support a comment like that?
Well, if you take a step back, when all of this blew up and initiated by the business competitor, the board's chiropractor was deposed and said she had no criticisms of Dr. Shine, no violation of standard of care. So what the board did was they went back to the patients and generated a quote reenactment video, and then bootstrapped off of that video from interviews from years afterwards, and then turned the experts around. And it also, in the context of the light of a record of a whole, patient 2 refuses to participate in any of this. Patient 3 is clearly stated she doesn't have any complaints against Dr. Shine. That's what makes me make that phrase, and I don't make that phrase lightly, Your Honor.
Right. And is there any indication that this case took an inordinately long time? I mean, have you handled these cases before, Mr. Cox? Is this standard, or?
I do not have context for that, but it does seem like a long time. And going back to the record as a whole, if if Ms. Shine were such a threat, there's a compelling logical force that the board could have stopped her or would have done something. I mean, there's a logical force to the fact that Ms. Shine has been treating for a decade, aside from the 89-day suspension, and has had no complaints or adverse outcomes. I mean, that's compelling.
But if that is our standard, though, wouldn't that encourage people to delay the outcome of their case so they could have lots of periods of compliance to show the board? Would that be an incentive to delay?
Would what be an incentive to delay? I'm sorry.
If the fact that you've been able to maintain a above board practice for the whole time the action is pending is a big mitigating factor in your case, then wouldn't that encourage delay?
I mean, the board wanted, if the board had its way, Dr. Shine wouldn't have been practicing these last 3 years. Judge Mason granted our stay
Right.
to allow her to keep practicing. So, not necessarily.
Okay. All right. Thank you.
I do want to clarify that there are Judge Mason affirmed or revoked the sanction based on 2 grounds in 77-621, which is C7 and C8, so even if the board does find that substantial evidence exists, they could still uphold Judge Mason's order based on it being unreasonable, arbitrary, and capricious.
Right. And
jumping to costs quickly so I don't run out of time, Judge Mason expressly held that the costs were arbitrary and capricious under 77-621 C8, and the board never appealed that or raised that issue. That issue is waived, in our opinion. And in addition to the arbitrary and capriciousness of it, you jump one statute over to 77622 on final remedy. Judge Mason is given broad discretion to fashion an equitable outcome. So aside from the fact that the board waived that issue and is barred, Judge Mason harnessed the authority in 77622, and that's an abuse of discretion standard, and I didn't see anything in the board's brief about that either. And the board has argued that Dr. Shine waived the issue of costs, but it was raised at every turn. And like you said, at the time of the ALJ's order, there was just a generic reference of costs. And then after the initial order, Dr. Shine appealed costs after every step.
Point to particular cost. Was there a dispute as to any particular costs in the costs that were assessed, or was Dr. Shine's position that the costs assessed were disproportionate to the sanction?
Well, if you look at the language of 652864, it does have proportionality and discretion related
Right.
to the case.
Right.
No case has ever interpreted that statute.
So my question was, did you on behalf of your client, did you dispute any particular entries that make up that? I mean, is there any dispute that the costs are $93,000? The question is, should that full $93,000 be assessed against Dr. Shine? Is there any dispute that the costs were $93,000?
I don't think there's any dispute to that's the universal potential costs, but Dr. Shine, after the initial order, argued for no costs and continued to argue that.
I understand that, and I agree. I think Dr. Shine has preserved the issue.
Okay,
I'm
great.
just asking, is there any dispute as to the costs, what the costs are, or is the dispute really whether, when you consider the sanction imposed, whether that those costs are disproportionate?
Yeah, I think it's more disproportionate.
Right. Okay. Thank you. Anything else, Mr. Cox?
I don't believe so.
Any questions from the Okay, Mr. Poling, you have your 5 minutes.
Yes, thank you, Your Honor. And first, I do want to clarify that Mr. Cox is correct that I misspoke. I said in regard to the two bases on which the district court relied, I said KSA 77621A7 and A8. It is C7 and C8. I just misspoke there. But the standard of review that I referenced is at A 77-621 A1 and A2. And Mr. Cox has argued that, that it's an abuse of discretion standard here. But again, based on KSA 77-621 A1 and A2, and this court's clarification of that in the 2018 case of Carlson Auction Services versus Kansas Corporation Commission, the standard is that the board's order is entitled to deference from this court just as it was before the district court. So for this court to rule in Appellee's favor, this court would have to not only disagree with the sanction chosen by the board in this case, this court would have to find that the sanction of revocation was outside the bounds of reason. And given the findings of 3 counts of gross negligence involving vulnerable pregnant patients that were made and upheld in this case, a proper application of that deference to the board's order, we believe, demands that the final order be upheld. So to be clear, we're asking this court to uphold the final order because that's procedurally where we're at. On this issue of causation, Appellee throughout this case has tried to raise this issue of injury and causation. It's just simply not a claim or defense that was ever relevant in this case. In a healing arts case, a professional misconduct case, it's not like a tort case where we talk about, injury, causation, damages. The only 2 elements to continue that analogy are duty and breach. Those are the 2 issues. And we don't, they have made much about the fact that our experts didn't, to a reasonable degree of medical certainty, opine that, the loss of these women's pregnancies were caused by Dr. Shine. It's because it's not an issue in the case. So we believe that's a red herring. It has been throughout this case. The other thing I want to clarify, which is again something that Appellee has repeated throughout this case, it was actually part of a successful motion to strike that was filed on our part. There were not 18 complaints filed in this case. There was 1 complaint filed relating to 3 patients. 3 patients. All of those 3 patients were found to have been, the victims of professional gross negligence.
I get what he was saying was there were originally 18 complaints, and then the peer review board and
Right.
whittled those down to 3. That's not correct?
That is not correct, Your Honor. Not correct. There was 1 complaint in this case. Now, what they're referring to is there was testimony from one of the complainants, who was a certified nurse midwife. She said that when she became concerned about Dr. Shine's care of patients, she looked at 18 patients that were mutual patients that had had adverse outcomes, and she found those 3 and said these 3 are a big problem. And those are the 3 that she submitted in her complaint to the board. So it is absolutely untrue to say that there were 18 complaints filed with the board and we, dismissed them.
And is that in the record? Is that clear in the record? Can we find that in the record?
It is. And I think, if you look at volume 3, page 19 of the record, volume 3, page 19, that's our motion to strike below. And that has the references. I'm sorry, I don't have the immediate.
Okay, no, that's perfect. That'll be great. Thank you.
But that is absolutely untrue. On the cost issue, we did raise it in our brief. And the problem here is that the district court, after finding on each of the three counts contained in the administrative petition for discipline, after finding each of those was fully supported and gross negligence existed as to each count, the district court then awarded 0 costs related to those counts for the costs for investigation and prosecution of the case. And the statute clearly says that when the board's order is adverse to the licensee, the board can award costs of investigation and prosecution of the case. And the district court, what the district court's decision was completely internally incongruent in that respect, because she simply just, awarded the costs for the transcriptionist for the administrative hearing, and that was it. 0 costs for any of the investigation or prosecution of the case. I think that, that the court's approach, the district court's approach to costs was summarized when the court wrote, quote, "The court finds the statement of costs to be excessive and not congruent to the limited suspension and small fine otherwise levied," end quote. That's at page 179 of volume 1. That shows one of the core errors that the district court made in regard to the approach to costs. The statutes, as we've cited in our brief, make it very clear that fines are punitive, costs are not punitive. And the district court clearly melded those two inappropriate. The cost analysis is completely separate from the sanctions analysis. Costs are not a sanction. They're neither punitive nor rehabilitative. They're generally ministerial in nature and a manner of accounting for the reasonable costs associated with investigating and prosecuting claims that are ultimately determined to be warranted. And in this case, all of the claims were ultimately determined to be warranted. The other point I wanted to touch on was the reference to our chiropractic expert, Dr. Hendrickson, saying that she had there was no criticism. That's not accurate. What Dr. Henderson testified was that Dr. Henderson needed more information. And in part, that was because the record keeping of Appellee was so poor. When Dr. Hendrickson got more information, Dr. Hendrickson opined that there was gross negligence in this case.
Thank you. I think your time is up. Any questions? No. Okay. Thank you very much. Thank you both. We will take this matter under advisement and issue a written decision as soon as possible.